The bank advised her to wait the 6 months until the CD matured and move the money then. From the bank's perspective, that advice made perfect sense. In order to fall under the older rules, the transfer had to be completed within 10 days. We explained that situation to the client and strongly recommended completing the transfers immediately. She decided to follow the bank's advice instead. By waiting 6 months to preserve about $3,000 in accumulated interest, she missed the deadline and ultimately lost roughly $84,000 in assistance from the VA over the next 3 years. When people start researching how to pay for long-term care, one phrase that comes up again and again, Medicaid Asset Protection Trust, that's often shortened to MAPT. If you read enough articles online, you might start to think Medicaid Asset Protection Trust is some kind of magic legal document. Set up the trust, move your assets into it, and suddenly everything is protected and Medicaid will pay for the nursing home. That's not how it works. A Medicaid plan often includes a Medicaid Asset Protection Trust, but not always. Whether a trust is appropriate depends on a person's specific situation, their assets, and how urgently they may need skilled nursing care. Some families benefit greatly from using a Medicaid Asset Protection Trust as part of a long-term strategy, while in other cases, a trust might not be appropriate at all, especially if someone already needs nursing home care and the Medicaid lookback rules are already in play. In other words, the Medicaid Asset Protection Trust is not the plan. It is simply one possible tool that might be used within a larger strategy. I'm Jeffrey G. Mersacci, the Plain English attorney and a certified Medicaid planner. And today we're going to dispel some of the misconceptions around Medicaid Asset Protection Trusts. First, I want to make sure that these kind of trusts are not like revocable living trusts, where you can maintain control of your own assets, handle your own trust investments, and give yourself money anytime you want to. Revocable living trusts are used to avoid probate as part of a powerful estate planning system, but they do not protect assets from a Medicaid spend down. Medicaid Asset Protection Trusts are irrevocable. And the reason the assets can be protected from a Medicaid spend down is not because of any magic language in the trust. The assets are protected because you have placed your assets and their control out of your hands and into the hands of a trustee. That's the real principle at play here. At its core, a Medicaid Asset Protection Trust is designed to remove certain assets from being counted when Medicaid determines whether someone qualifies for benefits. Because Medicaid has strict limits on how much a person can own, transferring assets into a properly structured irrevocable trust can sometimes help preserve those assets for a spouse or family members while still allowing the person to qualify for assistance with long-term care costs. However, the trust itself is only part of the equation. A well-designed Medicaid plan often involves a number of coordinated decisions. That includes how assets are titled, which assets should be transferred, which ones should not be transferred, and when those transfers should occur. Medicaid law also includes complicated look-back periods that penalize certain transfers if they occur too close to the time someone applies for benefits. Because of those rules, Medicaid planning is rarely about simply drafting a trust and calling it a day. The real work lies in developing a strategy that takes into account the client's health, financial situation, and the timing of potential care needs. Every once in a while, someone will call my office and ask a question that sounds perfectly reasonable on the surface. How much do you charge for a Medicaid trust? I understand why people ask that question. They're trying to compare prices and make smart financial decisions. But the question itself assumes something that simply isn't true. It assumes there is some standard, off-the-shelf Medicaid Asset Protection Trust that attorneys keep in a filing cabinet and simply pull it out whenever someone walks into the office. There is no generic Medicaid Asset Protection Trust that works for everyone. Every family's financial situation is different. Some people have significant real estate holdings. Others have retirement accounts, CDs, or investment portfolios. Some clients are planning years in advance of needing care, while others are already facing an immediate nursing home placement. Each of these situations may require a different legal approach. Trying to shop for a Medicaid trust by calling different attorneys and asking their price is a little like trying to interview a heart surgeon over the phone and asking what brand and model of surgical scalpel they use. The scalpel is not the important part. What matters is the skill of the surgeon and the strategy used during the operation. Medicaid planning works the same way. Another thing that surprises many people is how differently attorneys structure Medicaid planning trusts. Some attorneys prefer to place every possible Medicaid planning function into a single, extremely complicated trust document filled with special provisions, exceptions, and conditional sections designed to handle these different scenarios. Probate attorneys don't like this information getting out because it makes people wonder whether probate really is a big deal or not. If this sounds different from what you were told, please leave a comment. And if you want more straight answers, like and subscribe. While that approach can technically work, it often creates confusion because one trust document is trying to accomplish too many very different things all at once. At my firm, we usually take a different approach. Instead of trying to cram everything into one complicated trust, we often use separate irrevocable trusts designed for very specific purposes, with each trust serving a clear role within the overall Medicaid planning strategy. For example, one tool we often use is the Irrevocable Family Trust, which can hold certain financial assets that are intended to be preserved for family members. Another tool is the Irrevocable Property Trust, which can be used to protect a home or other real estate under the right circumstances. In some situations, an Irrevocable Special Needs Miller Trust may be necessary to help someone qualify for Medicaid when their income would otherwise exceed eligibility limits. And that's in certain states. And finally, there is the Irrevocable Funeral Trust, which allows funds to be set aside for funeral expenses without affecting Medicaid eligibility. These are all different tools designed for different purposes. If you want to understand how these tools work together as part of a larger Medicaid planning strategy, I explain the entire system in my free course. You can watch that at freemedicaidcourse.com, where I walk through the planning toolbox our firm uses and explain how each piece fits into the overall plan. Another misconception I see frequently is the belief that Medicaid planning can be done using the same estate planning documents that every attorney prepares. In reality, Medicaid planning often requires specific provisions that are not included in many standard estate planning documents. A good example is the Durable General Power of Attorney. Many attorneys draft power of attorney documents that place strict limits on the agent's ability to make gifts, often tying those limits to the federal annual gift tax exclusion. From a traditional estate planning perspective, that limitation can make sense. But from a Medicaid planning perspective, those restrictions can create some serious problems and take a lot of options off the table. In many Medicaid planning situations, the ability to make strategic transfers or gifts can be essential to helping someone qualify for benefits while still preserving assets for their family. For that reason, when we assist Medicaid planning clients, we almost always redo the durable general power of attorney they may have had from somewhere else so that it includes broad gifting powers specifically designed for situations when an agent may need to help the principal qualify for public benefits. Without those provisions in place, families can have far fewer planning options when long-term care becomes a necessity. The most important point I want people to understand is that a Medicaid Asset Protection Trust is just a tool. In many cases, what matters more than the trust itself are the specific transfers being made, the timing of those transfers, and the strategies surrounding them. A few years ago, we had a client who ended up losing about $84,000 in government benefits because she decided to follow the advice of her banker instead of the advice of her Medicaid planning attorney. The issue itself seemed small. Our plan required transferring several certificates of deposit into an irrevocable family trust. But those CDs had accumulated about $3,000 in interest, and the client didn't want to lose that interest by closing the CDs early. The bank advised her to wait the 6 months until the CD matured and move the money then. From the bank's perspective, that advice made perfect sense. But the banker wasn't thinking about Medicaid rules or Veterans Affairs benefit issues. At that exact time, the VA was beginning to impose a 3-year look-back period for transfers into certain asset protection trusts. In order to fall under the older rules, the transfer had to be completed within 10 days. We explained that situation to the client and strongly recommended completing the transfer immediately. She decided to follow the bank's advice instead. By waiting 6 months to preserve about $3,000 in accumulated interest, she missed the deadline and ultimately lost roughly $84,000 in assistance from the VA over the next 3 years. That is a painful example of how focusing on the wrong financial detail can lead to a much more expensive outcome. The lesson here is that Medicaid planning is not about a single document or even a single benefit. It's about strategy, timing, and coordination. Medicaid Asset Protection Trusts can be extremely powerful tools when they are used correctly, but they are only one part of a much larger planning system. A successful Medicaid plan depends on careful strategy, proper timing, and the coordination of multiple legal and financial decisions. If you want to understand how these tools work together and how a comprehensive Medicaid planning system is designed, I walk through the entire process in my free course. Again, you can watch it at freemedicaidcourse.com, where I explain the planning toolbox our firm uses and how these strategies can help families protect both their assets and their long-term care options. Again, I'm Jeffrey G. Mersacci, the Plain English Attorney, and as I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.